to only say I didn't want to harm my son by throwing him.
Which you accept?
Which we would accept, yes. They don't need to look at that. That area would be covered by a defence of necessity, which was discussed and was potentially rejected, or off the top of my head, I can't think of any other defence that potentially could operate in this circumstance. But the question of whether or not Mr. Bing wanted or desired the outcome to happen doesn't change whether on the Woolen direction what the outcome would be. You said that it was based on Nedrick. The fact, if I can go to tab 2 of my bundle.
Yeah.
The second page of the case provided, if the jury is satisfied that at the material time the defendant recognised that death or serious harm would be virtually certain, barring some unforeseen intervention to result from his voluntary act, then the fact from which they may that is a fact from which they may find it easy to infer that he intended to kill or do serious bodily harm, even though he may not have had any desire to achieve that result.
Yes. Neither Nedrick nor Woolen desired a result that was the opposite of that which they achieved, did they? Mr. Bing did. It may well be that we can't say that either Woolen or Nedrick desired death or serious injury, but they did not desire to preserve life or to avoid serious injury. And that surely is Mr. Bing's state of mind.
That may well have been Mr. Bing's state of mind. I'm sorry to keep going back to this idea, my lord, that that would be covered by a separate defence. One of the issues that has been why Woolen has been so well received by both practitioners and academics is the simplicity of it for a jury to understand. It is impossible to give a direction that will cover every circumstance, and in this instance, a separate direction on a possible defence would be appropriate. We don't know whether or not one was ever given, but that would be the appropriate way of disposing of
Yes, I see. I'm sorry, Mr. Shadow, I've forced you to repeat yourself a certain amount. Do carry on from where I first interrupted.
I think
I was going to say, how would you formulate necessity in the circumstances of this case, bearing in mind that we're not dealing, in the case of Bing, with medical necessity?
I would use the fairly standard, I don't get my brain skeletons, I believe they've outlined necessity in the first part of their skeleton, unfortunately I don't have the relevant section of the A. The act is needed to avoid inevitable and irreparable evil. No more should be done than is reasonably necessary for the purpose to be achieved, and the evil inflicted must not be disproportionate to the evil avoided.
It was taken from the conclusion of Lord Justice Brooks' judgment in Re.
Indeed, my lord. That would be the model direction I would suggest being given to the jury, possibly simplified into more everyday language rather than judicial statement to allow for the jury to understand it better.
Do you say that it may not have been inevitable, but you say that inevitable death might be proportionate in the circumstances if death was a certainty from the fire?
It's not clear on the facts as we've got them in the summary whether or not death was a certainty from the fire. Whilst, yes, if nothing happened, death would have been a certainty. He had options to mitigate the risk by throwing Ross out the window. If he waited till the absolute last possible moment before removing Ross from the building, the fire brigade may have arrived in order to help save them, or someone down below may have noticed that there's 3 people stood by a window and be in a position to catch Ross when he's thrown from the window.
Surely the criminal law generally makes allowances for human frailty in those situations, doesn't it? For example, think about the standard direction on self-defence. A jury considering the issue of self-defence, doesn't matter whether the charge is murder or common assault, would be told that they are not required to weigh to a nicety the precise amount of force that the defendant reasonably needed to use in order to defend himself. And so, to some extent, allowance is made for an overreaction on the part of the defendant. And in these circumstances, surely Mr. Bing must be allowed some leeway to judge in very short space of time what the better course of action for him to take was.
That would be potentially true, and we don't. Such allowances would need to be made. We don't know, based on the evidence, whether or not the jury would consider that when considering any alternative verdicts to murder. Don't believe there will be any further assistance on that point, unfortunately, my lordship.
What do you say about alternative verdicts? If we were against you on principle submission that the conviction for murder is safe and should be upheld, what do you say we should do about any potential alternative verdict of guilty of manslaughter?
The Crown would ask that the verdict be quashed in its entirety and remitted to the Crown Court for a retrial with the correct directions given to the jury, as the Crown would seek a charge of murder in a retrial as well. I'm not sure how long I have here. I don't believe I have anything further to add, my lords, unless I can be of any further assistance to you.
Can I ask you this? The example cited by Lord Justice Brooke was an example given by Professor Glanville Williams about description of a ship's captain being forced into selecting who would go into a lifeboat in a wreck. Do you say that there's a difference between the situation that Bing faced in this case and the situation faced by the captain of a wreck in those circumstances?
I would submit that there is, if the ship is sinking and there is absolutely no prospect of rescue beyond someone getting in the lifeboat and someone being forced to remain on the sinking ship, then there is a distinction there.
And where would you draw the line in terms of how many people were put onto a lifeboat?
My understanding would be that they would have a maximum amount of people they can take safely to be able to stay afloat, and that would be the number, rather than it'd be a matter of fact rather than a matter of law as to how many would go on. But I think hopefully that answers.
Do you say that if it's a matter of fact, there may come a point when the Crown, in assessing whether or not to proceed with a case, will assess the public interest by reference to the counsel of perfection, agony of the moment, position faced by somebody in a position akin to Bing?
They may do in that situation, my lord.
And how would you draw the line in relation to the law?
I'm not sure, my lord. I can't be assistant on that.
If you have somebody in Bing's position, faced with throwing his child out of a window to save him, at what point does he cross the line from doing something that he has to do in an emergency to committing murder? Is there any grey area between the two positions?
As a matter of law, I would submit that there isn't a grey area. It's a matter of fact as to whether or not he has waited until the absolute point where it becomes a necessity for him to act, rather than the overreaction. You would have to give some allowances for an overreaction, but that would be a question of fact for the jury to consider. It would not be a matter of law.
So we come back to necessity there. Do you say that anything turns on the word voluntary, which appears in the Nedrick test?
Yes, the act here was voluntary. He did have alternative choices. Even taking the most unfortunate example would be he chose to throw the 3-month-old baby out the window rather than, I hesitate to say it, pushing his 9-year-old daughter, who would stand a significantly higher chance of survival falling unaided.
The agreed evidence is that it was virtually certain that all of them would die if they went out of the window.
It's,
I mean, it's pure miracle that Mr. Bing and his daughter survived.
it is, my lord, but if you take an act and simply hope for a miracle to prevent the harm that your act is going to cause, that should not in and of itself provide a defence to you. There was a miracle that the two of them were saved. That doesn't mitigate the fact that he was the cause of Ross's death, and he had the intent to do so.
Do you have any further submissions?
My lords, can I give any further assistance?
Thank you very much, Mr. Chairman. Yes, more.
Good afternoon, Your Lordships. I should be dealing with the second point of appeal on behalf of the Crown. That is, that even if Dr. Geller had made her decision in the belief that it was necessary for Ross's long-term survival, medical necessity should offer her no defence, and therefore the finding in the Court of Appeal should be upheld. If I may proceed with my submission, my lords?
Yes, please do.
I'm obliged. I'd first like to begin with the case of Airedale NHS Trust and Bland. To demonstrate that ending a life in Norfolk can only be used in very limited and special situations and circumstances, and as such necessity shouldn't be used as a defence in the case at hand. If I may direct your Lordship's attention to tab 5 of the bundle, where we can see the case. Would my lords benefit from the rehearsal of these facts?
I think it would help me slightly, actually. I think that the Lord Douglas Jones is more familiar with them than I am, but if you could briefly just outline.
That's no problem. The facts here were that Anthony David Tony Bland was injured in the Hillsborough disaster. He suffered severe brain damage that left him in a persistent vegetative state, whereby the hospital, with support of his parents, applied for the court order allowing him to die with dignity. As a result, he became the first person in English legal history to be able to die by the courts through the withdrawal of prolonging treatments, including water and food.
Yes.
The Crown does recognise, before I bring to this case, my lords, that there is a large difference between cases involving such vegetative state patients and the case at hand, as obviously there's time to look in depth at the problems and look at possible solutions. But we would submit that Dr. Geller would have enough time to have asked for assistance from a fellow colleague. Or
Well, isn't there a more fundamental difference between the Bland scenario and the Irish?
Of course, Your Lordship.
We don't have a competing right to life in the Bland scenario, do we? We don't have anyone whose survival is risked or threatened by Mr. Bland in the way that arises in both the Reed A case, the joint twins case, and this one.
Of course, Your Lordship, I do completely agree with that. However, I'm using the case to merely state that there are certain circumstances and certain situations and instances that must be followed in order for the courts to allow life to be taken. And although I do completely understand where you're going from with this, I would actually submit that it's the fact that the doctor, Dr. Geller, had started treatment of patient Joey and had already begun life-saving, well, not life-saving treatment, but life-prolonging treatment, and to take in someone else and then to take life away from Joey makes the cases different, and in fact the case of Rie different from the case at hand, as that's a case where they've been brought in and the doctor is dealing with them together. These are two separate patients.
Do you distinguish factually between Bland and Joey?
I do, Your Lordship.
Can you just outline how you do that so that we can put that in perspective?
Of course, Your Lordships. So firstly, as I was saying, I do distinguish the fact that there is time constraints and there is the possibility to consult with other medical opinion and get legal advice and enable themselves to be able to get a court order and ask the families for their consent. But I would say one of the main differences between the fact of Bland, as my Lordship was saying, was that this was one patient and there was no conflicting patient for the right of life argument. So I would say that that is a main difference here. But one of the main important facts that really I do distinguish both the cases on is that of consent, consultation, and advice and court orders. As I submit, my lords, that is something that is crucial and is a crucial element. And without this, the doctor...
How would consent really have helped altogether? Because almost inevitably, Ross's parents would have said yes, and
yes.
Jerry's parents would have said no. And she'd be presented with the same choice to make, even if she had been able to.
Of course, your lord, my lord. I would submit that the crucial element would have been to gain a court order, as there is in fact an emergency telephone number which a doctor can phone at any particular time and will take you straight through to a judge, where you're able to raise your point of concern and you're able to see what the legal standing is there, and in hopefully be able to gain a court order, which is what I would submit the most essential thing that Dr. Geller has failed to do in this particular case.
The order of the Court of Appeal in the conjoined twins case did not make lawful that which was otherwise unlawful, did it?
No.
It identified the doctor's chosen course of action as a lawful course of action. And how, in real terms, is what Dr. Geller did different from what the doctors did in the conjoined twins case? Well, after the recourse to the court, I mean, not obviously there's a difference in having recourse to the court in the first place, but after the court's made its decision as to what is lawful, rather than rendering that which is otherwise unlawful, lawful.
As to what is lawful in that case, I would submit to you that this was because both of them were joined, and therefore, despite the fact that they were both different, were treated as being the same, as one was causing the death of another. The case is very different because in our particular case, we would submit that there is one patient who is receiving life support, and this is instantly taken away from her by Dr. Geller, which cannot possibly be right. That is where I draw my main distinction, my lord. I'd like to refer you to page 15 of the bundle, which is under the Airedale case I've just stated. It goes on to say there are certain important principles relevant to this issue in which both parties accept profound respect for the sanctity of human life, which is embedded in our law and our moral philosophy, which I would submit was disregarded in the case at hand. The second page, which is page 51, goes on to say, reliance on accepted medical opinion that feeding, nutrition and hydration, particularly by sophisticated artificial methods, is part of the life-supporting medical treatment. He says the duty to feed a helpless person, such as a baby or unconscious patient, is something different, an elementary duty to keep the patient alive, which exists independently of all questions of treatment, which the person in charge cannot omit to perform. Deliberately to perform this duty in the knowledge that the omission will lead to the death of the helpless one, and indeed the intention is in the present case of conducting to that death, will render those in charge guilty of murder. I would submit this is important for the reason that I've stated, that it's a continuance of the life treatment and not the beginning of a treatment. The sanctity of life argument is one that is very important here, I would submit, as there was a disregard for Jerry's life by the doctor who made an opinion, who made this thing completely by herself, that she was going to unplug the life support without consultation, without consent, which although isn't necessary, it is something that should be sought, as we should have regard to human life.
If you take consent out of the equation for a moment, and if you take the second baby, Ross, out of the equation, in the instant case, how do you distinguish between Bland and the case of Joe?
I would say the two things that your Lord has asked me to remove are some of the most important things that I would submit are crucial. The consent, for the reason that surely the parents would have had a right to say, even if they're disagreed, they'd have had the time to say goodbye to their child, rather than its life being taken away. So I would submit that's something that's very important. Aside from this, your Lordship, there is that of the court order which was gained in the case of Bland, which, or as you've said, this has said that it's actually lawful to take this life. This should have been sought, and the fact that it wasn't, and the fact that we're saying, if your Lords were to say that this is to be allowed, would in effect be giving doctors the ability to take a life from a patient without getting any of these things that we would submit are vital. I've actually run out of time now.
Oh. No, don't worry about that.
Okay, so as I was saying, I would submit that these things are absolutely vital and crucial. and the issue of life being extinguished without any kind of regard is something that the court should in no way uphold, because that can't possibly be right, can it? Although obviously I do completely agree with you, and I see the distinction between the case at hand and the cases that I'm citing. I'm merely using them to demonstrate the fact that in certain circumstances, medical necessity can be applied and allowed, but these are in very rare and special circumstances.
Can I ask how consent is relevant in the context of intention?
If Dr. Geller had sought consent, then there would have been the intention to remove Joe from the life support would have been made more, well, it would have been better. She would have gone further and should have sought things.
In terms of intention, by reference to what was a virtual certainty, by turning off the life support machine, does it matter whether or not you have consent?
For moral reasons, yes it does, and for the implication of sanctity of life, yes it does.
But we're not concerned
Yes.
with
It's not referable, you'd say then, to intention.
By not consulting, by not gaining consent, I would say that this shows that she had the direct intention to remove the baby from the life support with no regards to anything else, and with the direct intention of bringing about the end of Joey's life.
You must be saying, mustn't you, that Joey's right to life could not be overborne by what the doctor construed as Ross's greater need for the life support machine. If that were right as a proposition, how could consent alter the situation? How could Joey's right to life be overborne by his parents' consent to his death?
I would submit, Your Lordship, that consent is something not legally sought but morally sought. It's also something, it's a step which hasn't been taken due to the fact that she probably knew the parents would say no, and this would, in effect, not gain her the outcome that she wanted. So she took the decision upon herself to take action.
Well, you have now recourse to questions of morality, as I understand it.
Of course,
Doesn't that present you with some difficulty? I mean, Lord Brown Wilkinson, in the case of Bland, upon which you rely, says at the conclusion of his judgment, he recognises that his decision may well appear irrational to some on moral grounds, but he's nevertheless, but it is undoubtedly the law, and I think I have said cast doubt on the proposition, the doing of a positive act with the intention of ending life is and remains murder.
If I may actually direct Your Lordship's attention to tab 6, which is the case of the conjoined twins, and page 81, which is quite a way into the judgment. The 3 steps for necessity requirements are actually laid out.
Yes. I think my Lord referred to this earlier.
You have. Your Lordships have referred to this earlier, and so have both of my learned friends. But I would submit, as the case shows, none of these are followed, especially the last. The third point, that evil inflicted must not be disproportionate to the evil avoided. I submit that the taking of a life could never be an appropriate measure and could never be proportionate to the act that she was trying to gain.
Well, it was in the conjoined twins case, wasn't it?
It was indeed in the conjoined twins case, my Lord. But for the reasons that I've submitted, I would state that these are very different.
See, Lord Justice Ward in the conjoined twins case says, in fact, it's at page 49, which isn't reproduced in the bundle.
Okay.
The first important feature is that the doctors cannot be denied a right of choice if they are under a duty to choose. And wasn't Dr. Geller under a duty to choose here?
Yes, Your Lordship, she was. But not in the same way. The fact that she's in a hospital, in a ward, perhaps, she has medical opinion around her, which she should so easily have been able to gain. She has the emergency telephone number in order to be able to gain that emergency court order. Consent, although I feel is a moral issue that should have been addressed, those two alone remain and can be both independent of each other. The fact that she sought none of these things indicates that medical necessity cannot apply, as she took the decision completely independently, and the actions that she's chosen fell so short of the standard of care for a patient that we should expect from a doctor that we would submit the finding of, well, the argument of necessity cannot be upheld. That is the end of my submission, my lords, unless I can be of any further assistance to you.
For my part, no, thank you very much.
Of course, my lord.
Could you give me one moment, sorry?
Of course.
Yeah, thank you very much.
Thank you very much, my lord.
Yes, Mr. Owen.
My lords, in regard to my points of rebuttal, my learned friend Mr. Shirley respectfully submits that there was other options available to them in the circumstances given to Mr. Bing in the fire. However, my lord, I submit this not to be the case. This was a case of emergency. My lords, he was in the room with the fire approaching them. How could he possibly have had time to get a mattress out the window or even think about these possibilities?
Well, we don't even know if his mattress would have fitted through the window, do we?
My lord, I agree. This is a case of emergency. People do not think logically in emergencies, and it therefore cannot be respectfully submitted that there was other options available to Mr. Bing in this case.
There's certainly no evidence that the jury were invited to consider those alternative scenarios available to him either, is there?
Yes, my lord, I agree. Finally, my lords, I will conclude that the law in this case regarding virtual certainty should stay the same as Fulham. However, an exception does need to be made in these cases in order to clarify the law. My lord, I would submit, therefore, that an addition should be made to Willen to exclude cases where there was no other choice available to the appellants and where death was a virtual certainty in both cases. It is therefore that my learned friend and I submit that the appeal should be allowed based on the uniqueness of this case and the fact that this uniqueness does not enable the necessary intention to be found. And I henceforth conclude unless I can be of any further assistance to your lordships.
None to me, Mr. Hall, thank you.
No, thank you.
I'm very much obliged to your lordships.
Ms. Wells, are you going to respond further?
Yes.
Yes, please do.
My lordship, my learned friend, Miss Morton, submits that enough time would have been able to use the emergency phone or to get more clarification. My learned friend and I would suggest that there was not enough time, and in circumstances such as these, that the sanctity of life is important, but to disregard the life of Ross just because one child already was in use of the only life support machine does not allow that the medical necessity option should just be disregarded.
Yes, you say, I assume, Ms. Wells, that the doctor was obliged to make a choice.
Yes.
To use Lord Justice Ward's formulation. She was required, by the fact of Ross's right to life, to make a decision between the two, and that whether viewed from this perspective her choice was right or wrong, it's not right to fix her with liability for murder on the basis of that choice.
Yes,
She was required to make it.
The duty of doctors are to make such difficult decisions that most people would not be able to make, and it's their duty to make these, and to be dissuaded by making these decisions would be to put the law into an area that it does not want to be in. And my learned friend put a lot of emphasis on morals, but this cannot be the overarching principles in regard to medical necessity. And to look at it, medical necessity is something that doctors should be given, and this is one of those limited circumstances that my learned friend and I would suggest should be allowed.
Can I ask you this? Morality was touched on in the context of consent. What relevance do you say consent has in law?
Consent is important when it offers a valuable help to the case, but in this circumstance, as your lordships pointed out, consent would have made no specific difference to the facts of the case. Had Ross's parents said yes and Joey's parents said no, Dr. Geller would still be in the same position.
Did you say that consent has any relevance at all in the context of medical emergency?
No.
And what about in the context of the criminal law?
In the criminal law, but not in circumstances such as this, where time is of the essence, and there are circumstances where two children, one of which is more capable as assessed of life, and the other was going to die as a result anyway.
Can I ask where you draw the line in factual terms between what's an emergency and what is not an emergency?
Emergency is where one, especially in conflicting decisions, where one child is capable of life and could perhaps be saved, but the other child is just being prolonged life that will ultimately end as a result.
But there may be, time may not be the essence of the essence in that scenario, but at what stage does it become of the essence? When does consent become material?
When there is no other option and one patient is of need to have something done and the other patient is taking that away from them, even though that they would unfortunately die as a result. My learned friend and I would suggest that the appeal should be allowed, and that is where I conclude unless I can move on to further assistance.
Yes, thank you very much, Ms. Mark. Now, I don't know whether, I can't remember whether the rules require there to be a response to the response. They do, right, okay.
My learned friend has suggested a supplemental to the Woolen test, which would, in essence, staple onto it the idea of necessity. The saying when there's no other option, such terms would essentially be to give the jury both directions in every circumstance. This is not appropriate. As I submitted earlier, that the elements of the defence do not change, the elements of an offence do not change.
I don't understand give both directions in every circumstance. Nobody would suggest that the necessity direction would need to be given in Woolen, would it?
The supplementary moral direction that my learned friend suggested a few moments ago was slightly different from necessity, was tantamount to the same thing. And that she was therefore suggesting that it would be appropriate to give such a direction in most cases. Where I would submit that the Woolen direction as it stands now is well settled law and should be left as it is, and it is for necessity or other defences to supplement that where appropriate as deemed by the trial judge. That would conclude my response unless we have any further assistance to your lordships.
No, thank you, Mr. Chair.
In my response to my learned friend, I would submit that the way that Dr. Geller acted was not in accordance with best medical practice for the reasons that I have stated. The fact that she acted independently furthers this point and should no way be allowed by the law to have been so, because in doing this and in allowing this, we are in effect giving doctors the right to extinguish life of patients with very little regard to the law, with very little regard to seeking medical opinion from their colleagues, and without seeking any kind of legal opinion or some sort of court order, as was stated in the other two cases I've mentioned. So in allowing so, we are giving doctors the ability to kill patients, which in no way should be right, and therefore the doctrine of necessity should not be able to be developed, as my learned friend has submitted.
Don't doctors frequently make decisions which may well have the virtual certainty in terms of consequence of death?
I would submit to my lord that they don't make these decisions independently and of spare of the moment, and they don't make these rash, fast decisions. I'd also like...
Isn't that at the heart of particularly emergency medicine? Decisions have to be made on the spur of the moment.
I do agree with you. Where I'd like to distinguish, and probably the most important thing that I should have put into my submission, was the fact that the machine had broken earlier that day. For necessity to have taken place, or for the doctor to have been allowed to have done this, she should have then made the decision to have taken Joey off the life support machine. For the fact that this could arise later, she should have made the necessary steps. The fact that she waited, she had both babies there, she asked no one, she sought no legal opinion, but then made the decision to unplug Joey for the life of another who may not succeed. The fact that she'd started treatment and she had put the baby on this life support machine meant that she owed this baby a higher duty of care, and the fact that she extinguished it with very little regard means that necessity should not be upheld.
Well, she wasn't required to make any choice. One option within which would be removing Joey from the life support machine until Ross arrived at the hospital, was she? So how was she supposed to foresee that there might be a need
Of
for a
course.
different baby in the life support machine until that need arose.
Not foreseeing the need, I completely agree with you, Your Lordship. However, knowing that there is one machine being used by one baby, she should have then, because she's the only one who's given any sort of medical opinion on the baby, she should have made it her case that she wanted to seek alternate things. So she thought the baby wasn't going to live for very much longer.
Well, supposing the life support machine hadn't broken down, the second life support machine hadn't broken down, but there was another baby in it who had a better chance of survival than Joey did.
So you're saying those two have both been used and then another
Yeah.
baby comes in?
Yeah.
Well, still, I don't think independently she has the ability, without seeking any sort of court order, because as I've said, my lord, that is then leaving the law very unclear and is saying, in effect, that doctors can make spare, rash decisions off the top of their head to take away life of a being.
So at any time when she doesn't have available to her a spare life support machine, she needs to assess the liability of continuing to administer treatment to any patient that is in a life support machine.
Well, surely that should be the standard of care that we expect of a doctor, and we expect of a medical professional. We should expect them to take into account any kind of circumstance. They should take into account legal proceedings, they should take into account court orders, they should take into account consent. And although in a quick decision, this obviously isn't all going to be able to be processed, at least one of these things should have been sought. And the fact that it wasn't means that she was in no way acting purely on necessity, but also with intention to end a life. And that is why we would submit that the finding in the Court of Appeal should therefore be upheld.
It's all about balancing interests, isn't it? And she hasn't got an interest against which to balance Joey until Ross arrives.
This is true, Your Lordship, my Lordship, but she does have an interest to look after the patient to which she is already put on the life support machine and she is already administering treatment. And this should therefore be upheld. And to take away the life so quickly doesn't quite make sense, either in law or morality, I would argue.
You say the defence of necessity doesn't apply, is that right?
Yes, Your Lordship.
Supposing for a moment I'm a doctor, I'm faced with a decision whereby I have to take a positive act in relation to a child, such as Joey, which is likely to kill that child, lead to the death of that child.
Yes, my Lord.
You say that I can render it lawful by contacting the High Court, is that right?
I would say you would seek their opinion and you would seek a court order. And if this wasn't gained, then you probably shouldn't do the action because you have legal advice on the subject. However, if you were to take one of those steps, any step to show that you have thought of what is happening, then I would say that, again, I would state that medical necessity is only used in very particular and slight circumstances, and as such I'd still submit that it wouldn't be available to Your Lordship.
Does medical necessity come into play if it's 4:30 on a Friday afternoon and I ring up the High Court and the relevant designated High Court judge is dealing with another medical emergency?
I've been informed, my Lord, that they will always be available and there'll someone always be there to take care of your complaint or your problem and be there to address you.
What if there simply isn't time?
There should be time. There is also the fact that the patient hasn't just miraculously popped up in the hospital. There would have been a telephone call perhaps from the ambulance saying, okay, we have a small child coming in with severe brain damage or whatever it was that was stated in the facts. This is what's going to be needed to be done. And doctors would have had time, even if it was a 3-minute interval, to have made the decision that, okay, we have a child on a life support machine, these are the steps that we need to take. As none of this was done, I'd submit it was a rash decision, and in allowing a doctor a defence of necessity can only be a wrong and can only lead the law in such muddy waters as to say that doctors are able to do this without following steps, and we would submit that can't possibly be right.
You say that medical necessity wouldn't come into play at any stage, even if, for example, there wasn't enough time to explain to a judge the relevant circumstances with sufficient clarity and detail for him or her to be able to make a decision.
I would say then perhaps it would, having regard to the fact that there would be other people of medical knowledge around you who you could quickly consult with. Again, you'd have had the period of time on the way to the hospital where you'd be able to acknowledge the injuries that were coming to you, and you'd have time to quickly consult. I think no medical person should be able to make such a rash choice completely alone and independently of consult of legal advice or a court order and medical opinion.
You shouldn't ask to make this this choice, did she? She was forced to make it because she was presented with a baby who had fallen out of a block of flats, who, if he wasn't put in the life support machine, would die.
Yes, Your Lordship. I do submit she was in a very difficult position, but as I have stated, I think there are certain avenues that she could have gone down which she didn't, which does take this right away from her, as it does seem to be that she took this completely alone. And I would submit that can't possibly be right.
Did you say that there comes a point if she'd had discussions with other medical personnel whereby there would not have been a commission of murder?
I would say that at this point, perhaps necessity could have been available to her because she has shown that she has the requisite knowledge and that she's made enough to be supported by medical opinion, and that therefore she's not acting independently, but she's being followed by a governing board of opinion.
Yes, thank you.
Thank you very much, my lordships.
Thank you. Well, were this the real Supreme Court, I suspect their lordships would take about 3 months to render a decision. We haven't got 3 months, nor do we have 5 law laws, but we'll do the best we can, and I think we'll probably be back in something like 20 minutes.